Welcome to the Deep Dive. Today, we're getting into something really foundational for Nevada real estate. It's the duties owed form.
Yeah, absolutely. We've got the official stuff here, FAQs, a supplemental form, the main document itself, all straight from the Nevada Real Estate Division.
Right. So our goal here is to basically unpack what this thing is, why it matters, and what it means for you if you're buying, selling, or heck, even just curious about Nevada real estate.
Exactly. And it's worth understanding even if you're not in the market right now. These are the baseline rules for how agents operate. It's pretty insightful stuff.
Totally. Okay, let's just jump right in. Why does this form even exist? What's its main job?
Well, the real estate division, in their FAQ, puts it pretty plainly. Quote, "The purpose of this form is the disclosure of the licensee's duties to both the clients and the public." So really, it's about transparency.
Disclosure, making sure everyone's on the same page about the agent's obligations.
That's the core of it.
And it's important to stress, this is just a disclosure, yeah. It's not like the contract where you hire the agent or agree to pay them. All the documents seem to really hammer that point home.
Absolutely crucial point. It is a disclosure. The FAQ mentions it's required by state law, NRS 645.252, SPEP Section 3. So it's not optional. But, and this is key signing, it does not create an agency relationship. That's a common misconception.
Right, okay. So acknowledging you've seen the duties doesn't mean you've hired that person. That makes sense. So who actually needs to put their signature on this thing?
The division basically suggests everyone involved gets a form to sign. Each party.
Everyone.
Yeah, ideally.
Yeah.
The FAQ breaks it down. Listing agent gets the seller's signature. Buyer's agent gets the buyer's signature.
Okay, standard stuff. But what if someone doesn't have an agent? Like an unrepresented buyer, maybe?
Good question. If there's an unrepresented party, the one agent involved, say, the seller's agent dealing with an unrepresented buyer, has to get the form signed by both their client, the seller, and that unrepresented buyer.
Ah, okay. So they have to make sure even the person without an agent gets this disclosure.
Exactly. And this even applies if the licensee is buying or selling their own property and the other side is unrepresented. They still have to provide the form and get it signed.
Wow. Okay. So it's thorough.
Yep. And that signed copy needs to be in the broker's file for the transaction. It's about proof of disclosure.
Makes sense.
Cool.
All right. We know who signs. What about when? Is there a deadline?
There is. It's laid out in the Nevada Administrative Code, NEC 645.637. The FAQ quotes it. It needs to happen as soon as practicable.
As soon as possible, basically.
But no later than the date and time on which any written document is signed by the client or any party not represented by the licensee or both.
Okay, any written document. What does that actually mean in practice? Like, what kind of documents trigger this deadline?
The FAQ gives examples. Think listing agreements,
Right.
purchase agreements, lease agreements, property management contracts, even things like a letter of intent or a buyer brokerage agreement.
So pretty much anytime you're signing something official related to the deal.
Exactly. Any key document where you're formalizing something. The duties owed form needs to be handled by that point, at the very latest. Earlier is better, but that's the cutoff.
Gotcha. Now, I saw something about confirming the representation, too. What's that about?
Yeah, so that same regulation, NAC 645.637, also says the disclosure needs to be confirmed in a separate provision incorporated in or attached to that document.
Meaning?
Well, the FAQ explains that a lot of standard forms like purchase agreements, listing agreements, they often already have a clause built in that states who the agent is representing in that specific deal.
Oh, okay. So it might already be covered in the main contract itself.
Often, yes, but if it's not explicitly stated in that main document,
Then what?
then you need a separate standalone confirmation of representation disclosure. It gets attached to make sure it's crystal clear who's working for whom.
Clarity is key, seems like.
Definitely. Now, speaking of clarity, what about situations where one agent might end up working for both the buyer and seller? Dual agency.
Right. That can get complicated. Does the duties owed form mention that?
It does. If you actually look at the form, just above where you sign, there's specific language acknowledging that the licensee might act for both parties. The FAQ highlights this too.
So is a heads up right there on the form?
Sort of, yeah. It puts the possibility on the table, but just acknowledging it isn't enough to actually do it.
Okay.
To legally act as a dual agent representing both sides, the agent needs to get specific, informed consent before they start acting in that capacity.
Ah, so there's another step involved.
A crucial one. There is a completely separate form for this. It's called the Consent to Act, Form 524. Everyone involved has to understand the implications and sign that form before the dual agency can actually happen.
Okay, so the duties owed form mentions the possibility, but the actual agreement to dual agency is a separate form. Got it. Now, there was another form mentioned in the materials, the Supplemental List of Licensees, Form 525A. What's that one for?
Ah, yes, the supplemental list. The FAQ explains this is mainly for situations involving real estate teams, where you might have multiple licensed agents or licensed assistants working together under one broker on a transaction.
Okay, like Team XYZ Realty or something.
Exactly. This form, 525A, lists out all the other licensed individuals on that team who are also bound by the same duties we've been talking about, the ones in NRS 645.252 and .254.
So it's making sure you know everyone licensed who might be involved and that they all have the same responsibilities.
That's the idea. Transparency again. The form itself has spaces for their names and license numbers.
And do clients sign this one too?
Yep. There are signature lines for both the seller landlord and the buyer tenant to acknowledge they've received this list of additional licensees. So everyone knows who's officially part of the team working on their deal.
Okay, that covers the paperwork side pretty well. Let's get back to the core, the actual duties listed on that main form. What are agents actually obligated to do?
Right, the nitty-gritty. The duties owed by a Nevada real estate licensee document breaks it down into two main categories. First, duties owed to all parties in the transaction.
Okay, duties to everyone involved, regardless of who hired the agent.
Exactly. These are the baseline rules of professional conduct. The big one is the duty to disclose all material facts of which the licensee has knowledge that might affect the value or desirability of the property.
Material facts, that sounds important. What counts as material?
Well, it's broader than just like a leaky roof. It could be zoning changes coming up, known issues in the neighborhood, maybe even significant past offers on the property. Basically, anything a reasonable person would likely want to know before making a decision. It's a serious obligation.
Okay, disclose important stuff. What else is owed to everyone?
The other main one is to exercise reasonable skill and care. This just means acting competently and professionally, doing their job properly.
Right, those apply universally. Now, what about the duties owed specifically to the agent's client, the person they actually represent?
Ah, now these are the fiduciary duties. They go deeper. First up is loyalty to the client. The client's interests have to come absolutely first.
Ahead of the agent's own interests, or the other parties.
Absolutely. Then there's obedience to lawful instructions of the client. If the client asks for something legal, the agent generally has to do it.
Loyalty and obedience. Makes sense for your own agent. What else?
Next is disclosure to the client of all information obtained by the licensee that is material to the transaction, but with a key exception. And that is not confidential information obtained from a present or former client.
Okay, unpack that a bit.
So if your agent learns something that could help you, maybe the seller is super motivated, they generally have to tell you, their client. But if they learn something confidential from a previous client, like their top price on another deal, they can't share that with you now. Client confidentiality survives.
Ah, so they share info with you, unless it's someone else's confidential info they already have.
Precisely, which leads directly to the next duty, confidentiality. Protecting your private information unless disclosure is actually required by law, like a court order or something.
Keep the client's secrets safe. Got it.
Yeah.
Are there more?
Two more key ones for the client. Reasonable diligence, which means working hard and efficiently for the client. Being proactive.
Not slacking off.
Right. And finally, accounting. Properly handling any money or property that belongs to the client that the agent is holding during the transaction, like earnest money deposits, for instance.
Okay, wow. So there's a clear difference between the basic duties owed to everyone and these extra higher-level duties owed just to your own client.
A very important distinction to understand, yeah.
Now, if people listening want to see these forms for themselves, where can they find them?
The FAQ gives the website red.nv.gov. That's the Nevada Real Estate Division site.
red.nv.gov.
Yep. And the FAQ says you hover over forms, click disclosure, and then select the duties owed form. The supplemental list should be there too.
Pretty easy to find then. What if someone has, really specific questions or a complex situation?
The FAQ also lists phone numbers for the division's enforcement section, Carson City and Las Vegas offices, and an email address, realist@red.nv.gov.
Good to know there's a direct line.
Yeah, and it mentions the FAQ was put together by the chief investigator with input from a commissioner and a broker, so it's coming from people who really know the rules inside and out.
Definitely sounds authoritative.
Oh.
Okay, so let's try to wrap this up. The duties owed form in Nevada. It's basically a foundational disclosure.
Absolutely. It tells everyone what the rules of engagement are for licensed real estate agents, what they must do.
Both for everybody involved and then those extra layers of duty specifically for their own client.
Right. And remember, it's required by law. It's not a contract for services. And signing it doesn't automatically mean you've hired that agent.
Crucial points. Understanding this really does seem like it empowers anyone involved in Nevada real estate.
It does. Knowing these duties helps you know what to expect, what your rights are, and what level of service and honesty you're entitled to.
So thinking about all this, maybe a final thought for our listeners. How does knowing about these specific legally defined duties change how you might approach working with a real estate agent in Nevada? What questions does it make you want to ask up front?
That's a great takeaway, thinking about how these duties play out in a real transaction.
Yeah.
Definitely food for thought.
Absolutely. Well, thanks for breaking down this really important Nevada document with us today.
My pleasure. It's essential stuff.